Okay, there we go. So we are recording now, so the meeting is going to start. So thank you, everybody, for your attendance at the December 2023 meeting of the PRC. We have some regrets, so I'll go through them. And universally, those who provided their regrets did want to pass along the best of the season wishes to the members of the PRC who are here, so we certainly will do that. So Peter won't be joining us. Lynn, Howard, or Brendan, although we have some bit of material from Brendan when we get to his report on the Justice Committee that he's responsible for. All right. So first things first, I need a motion to accept the agenda as circulated for this month. Irving, seconded by Stefan. There we go. Thank you very much, guys. All in favor? Carried. Thank you.
It's almost basically unanimous consent.
Yes, it is. And can I have an approval of the minutes for our last meeting, which was actually October the 10th passed? So a motion to accept the minutes. Thank you, Matthew. A seconder, Richard, and all in favor? There you go, unanimous. Thank you. All right, everybody, that's great. Okay, so let's move to news and announcements and what have you. The first note is regarding Peter and the Alberta government's attempt to institute a police service. And Peter indicates in his absence that he is still working on a brief for us. So he'll present that to us when it becomes available. The next item is, and this is somewhat historical now, the letter to the Minister of Justice dealing with our position on the law of extradition. So that's moved forward. Irving, did you hear anything back in response to that letter?
I'll tell you, Miles, I haven't heard back on anything from the government.
Okay.
Just as an aside, I communicated with a number of federal cabinet ministers regarding potential support for our next Congress. That was, we probably mailed them out. It's got to be at least, I don't know, at least a month and a half. I haven't heard back a peep from anybody on anything. So I really don't know what's going on, frankly.
Okay. Where is the next Congress?
It's in Banff, October 6th to 9. Banff, Alberta, of course, October 6th to 9.
Very good. Thank you. Good to know.
2024, of course.
Irving, does the Minister of Public Safety, doesn't he provide a small grant?
Nothing is automatic. You got to beg. But, in direct response, I've got nothing. We wrote to, the topic is primarily around Indigenous issues and so on. And I included individually, I wrote to the two different federal ministers on Indigenous issues, and they didn't write back. I wrote public safety and so forth. So I don't know what's going on. I think they're trying to get their collective acts together. I imagine. You've seen they've been in trouble in a number of areas, crises of one sort or another, and so on. So maybe that has everything to do with it. There were budget issues, obviously, and I'm asking for money. There was, I think I probably mentioned this last time. They got a letter from Treasury Board, each minister, each department, saying you have to cut your budget by 3% going forward. So they're probably still analyzing potential implications. I'm guessing. I can't say for sure. But the end product is, Miles, we have no response on that letter, and I've got no response on anything subsequent.
Okay, well, that's thank you.
Not good news, but that is where it's at.
Understood. Thank you. All right. So the next active issue on the news is, I guess, is my appearance. I appeared before the Standing Committee on Justice and Human Rights on November the 7th, dealing with Bill C-40. That's the Miscarriage of Justice Review Commission bill, and I circulated to members of the PRC the link to, if you actually wanted to take the time to watch those proceedings. As it turns out, it was a really good thing that I appeared in person, because the committee at the beginning of the hearing went on at length at the technological difficulties they have in doing the instantaneous translations for those who are connecting by Zoom. And so of all the people who were supposed to appear at the same time I was, there's two panels and I was in the second panel, but they actually couldn't permit people to go forward and do their online presentations because the translation wasn't working properly. And and apparently that's the case. That's been the case for the last year and a half. And so a number of the committee members were really upset about how this was dragging on. And so those of us who appeared basically had the floor for much more time than would be normal because other people could not present. For my presentation, it was great because, as it turns out, I ended up being the only person in the second panel, and the panel goes on for an hour. So they did have somebody who started to present, but then they had to cut her off because of the translation problems. So I ended up having a lot of time with the committee, and I really enjoyed it. It was a really good experience.
Great job.
Yeah. And
Miles, I had a chance to listen to your testimony, a good chunk of it. It was an absolutely superb job.
Oh, thank you.
Yeah, very good.
In fact, you were very professorial, and you had the knowledge at your fingertips on the questions. It really makes our association look wonderful.
Well, that's very kind. Thank you, Matthew. Yeah. I hope it was. I think it went well. Interesting enough for me. I mean, obviously the purpose of the appearance was to promote the addition of compensation into the statute, which was the centerpiece of my argument. But I think it's a function of the time that I was allocated. I had a fair number of questions that dealt more broadly with the act itself and much beyond just the issue of compensation. So that was very good. And then after the meeting, I had a number of the committee members who came up to me and asked me to send them additional material directly, and I certainly did that. So we'll see what happens. I think the committee meetings are for the most part now complete. November 29th was the last day that I saw being scheduled. So they'll generate the report, however long it takes to generate the report. And there are some significant issues on this issue of the commission that the bill did not address as promoted by the Reform Committee. Some important issues. So we'll see what happens. And then whenever we get a report, I'll report back to the PRC on how it's going. So there we go. So again, thank you, Matthew, for those kind words. And we'll move on. The next issue we have, and this comes from Howard. He sent us a release from the Canadian Bar Association on the collateral consequences of criminal convictions. And I've put the link in there for everybody to take a look at. If you had a chance to read it, it's really quite informative. It really basically is a primer for counsel, to a great defense counsel, to a great degree, is to pay attention to the sentencing that's going to take place if their clients are convicted. What will happen to their clients pretty much for the rest of their days as a function of a conviction. Right, and so that's what the collateral consequences talk about, and it's very telling. So I recommend that to anybody to take a look at, because and certainly it's directed towards defense counsel, but for our purposes, from a policy point of view, it's pretty important to keep a handle on what the ramifications are of convictions and how they affect the people that are subject to those. And the next issue we had, this came from Stefan, and Stefan's joined us, so that's great. This deals with the Smart Justice Network, the Lift Me Up question regarding the mums on the CSC's latest public relations campaign. Stefan, do you want to say a few words on that?
He's on mute.
Yeah, we need to hear you. Can't hear you, Stefan. There you go.
But I thought just in case, whatever. So it's been a while since I read it, but basically, I think it's important for any organization, especially the government organization, to be forthright about what they're advertising, what they're saying as to what they do, and give solid examples to back it up. So I just thought, you don't want more negative feedback or attention by misinformation or disinformation from the people that are under lots of pressure at times also to explain to the public why they're doing what they're doing, or why they're not doing what they're supposed to be doing. So that's basically my comments.
Oh, thanks, Stefan. Any questions or comments for Stefan?
I didn't understand exactly what was being proposed by this group. They were complaining about the communications from Corrections Canada?
Well, as I recall, it was a short little article or message. Basically, they were saying that Correctional Services Canada was representing itself as doing all this great stuff with offenders, inmates, whereas in fact it's not so rosy. And I don't know if that comment gets into, but that person who wrote that short little blurb article talks about the specifics. It just talks about the fact that you're painting one picture, but the reality is much more dismal in terms of the success Correctional Services Canada. Yeah, so that I just thought, yeah, that was interesting that if in fact it's true, because I don't know what Correctional Service Canada was saying, but I think it's good to be transparent and back up, claims you make to the public in particular.
I haven't read the specifics. I haven't seen them, but the last meeting we had with the commissioner, she talked about the communications pieces that are coming out, indicating some of the positive things CSC does and the challenges for staff and so on. I thought it would have been a positive initiative, but obviously that doesn't change the fact that for those who are incarcerated, time is still difficult to do, right? And obviously there's impacts on families and so on. I doubt that the commissioner or CSC was going to say that it's wonderful to be incarcerated. I don't think that was the point.
I don't know if that person who wrote that little article or that complaint had the structured intervention units in mind or what, but anyways, it was a negative thing that was said about the feds, and whether it's true or not, I don't know. But someone saw it that way. Can't please everybody, I guess.
Right. Well, at least they're communicating.
Yeah.
Yeah, thank you. Any other questions or comments for Stefan? Okay, very good. Thank you. Okay, so let's move on then to the justice-related parliamentary committees. Oh, yes, Andrea.
Sorry to interrupt. Just before we move on from kind of news and current articles, I just want to flag for everyone that the verdict in the Fakari inquest, which is a 3-week coroner's inquest that just wrapped up last week, the recommendations and the jury verdict are being released kind of as we're meeting right now in the media, and it's a big case for Ontario. This is the case of a death in custody involving a Muslim inmate who is severely mentally ill in an acute state of crisis, who ends up getting into an altercation with the officers during movement from the shower to his cell, and subsequently dies. And so I just want to flag for folks that I think there's some big policy recommendations going to be made I received the verdict, but I haven't read it yet, in this related to mental health and corrections, and a lot of it also being about the disconnect between correctional health and community health, and the requirement for equivalency. So I just want to flag for people that that's coming out today.
Thanks, Andrea. We're going to put that on the agenda. We'll add that in and then come back to it in our next meeting and hopefully with an update on that. That was in Lindsay, right? The central, east.
That's right.
Yeah, super.
We had the Ontario affiliate. We had a meeting last week, and I'm chatting with some of the folks who are working in Attorney General or public safety. I was shocked when I read some of the testimony from one of the officers about how this individual was handled. And even if he hadn't had mental health issues, just the way they grabbed him and basically asphyxiated him. And it reminded me exactly of what happened at Kingston Penitentiary 30 years ago. Matt might recall that, the Gentles case. So it's like, it requires such basic training. It's hard to imagine that these officers so screwed it up.
Yeah, it was, I mean, I missed the last week of the testimony, but I testified on behalf of the coroner's office at the inquest. And so it was a really, really interesting inquest that heard a lot of different people's perspectives, including the officers and yes, Irving, to your point, some of the testimony from was infuriating and just shocking to me.
Yeah.
You know, it's a shame, I think, from my knowledge and my reading and my limited experience in prisons, the prisoner culture versus correctional officers. It's something that's deep seated, and I really hope that the feds pick up on the recommendations made by the jury and not just dismiss. I don't know what they are, but dismiss some because they think it costs too much money or it's not worthwhile because it is worthwhile. These people have needs and feelings, and they have family. And as Nelson Mandela said, you look at society, how they treat their criminals. That reflects on sort of the culture and ethos of the culture, so of society. So hopefully they follow up on this and bite their teeth into some of these policy recommendations and create realistic policies. So those are my thoughts.
Thanks, Devin.
Yeah.
Thanks, Devin. Irving, Andrea, thank you very much. So again, we'll revisit this next meeting. Any other news or announcements we should put in here before we move on to the parliamentary committees? Okay, the first committee, Justice and Human Rights, that's Howard. Howard is away, so hopefully when he returns next month, we can get an update on what's happening there. Next is the Commons, Public Safety and National Security. That's Rob. So Rob, do you have a report for us?
Yes. So we're talking about 2 months of meetings here. So I'm gonna try to be, as brief as I can be. So we had they had 14 meetings. So in the month of October, they were mainly focused on Bill C-20. By mid-October, there was some concern again about the Bernardo transfer. So they actually they're supposed to be talking about Bill C-20, but they ended up throughout the next 3 meetings discussing back and forth about having future meetings about the transfer of Paul Bernardo and who to invite, etc. So this went on between the members of the committee for approximately 3 meetings before finally agreeing to something. And then they went on to continue clause by clause review of C-20. That's, by the way, C-20 is the bill regarding the Public Review and Complaints Commission, basically an independent oversight body, establishment of an oversight body for the RCMP and the CBSA. So they went on and throughout the next few meetings, clause by clause review, bring us to November 8th. On the 8th, they also had some committee business where they decided to allocate $32,000 to study car thefts in Canada, mainly focused on a problem focused on Montreal. A lot of car thefts in that area. And a briefing, decided that they would hold a briefing or receive a briefing on trauma-informed practices. So then we're on to November 20th. They elected a chair. The name of the new chair is Heath McDonald, who's a Liberal from PEI. Then the topic shifted to, on November 22nd, to the rights of victims of crime, reclassification, and transfer of federal offenders. So these are the meetings that they had to reached an agreement on what to do about back in October. So now we're on to the Bernardo transfer and rights of victims, etc. So they had 1, 2, 3, 4 meetings on that. And then it appears as if on December 6th, there's no evidence or minutes, and there's a reference to drafting instructions for a report. So it appears, if I'm understanding it correctly, that they're done talking about those issues and seem to be possibly prepared to draft a report or some on that. So for the Bernardo transfer, there was just kind of sum up who appeared and what some of the topics were. So we had the union, UCO, the Correctional Officer Union, as well as USJE, the president of UCO and some regional VPs from the USJE. There was discussions with them about their custody rating scale, the validity of that, and that's the tool used to that CSC uses to rate the classification of offenders. It can be used, the result can be used more or less as it comes out of the tool, or it can be overridden. So there's some discussion around that, the overriding of the tool and their thoughts on that. Also, some discussion on the terms used in law over the years, least restrictive measure. And I believe now it's measures that are necessary and proportionate. So, you know, what it should be or could be, or some finger pointing back and forth on which government was responsible for that language in law over the years, because it has shifted a little bit, you know, here and there over the years. We had the CSC commissioner and a couple of assistant commissioners from CSC, the deputy minister from the Department of Public Safety, DG of Community Safety, Office of the Correctional Investigator was provided some information. They broke down like who knew what and when to some extent, like when the transfer took place, when the minister's office was notified. Much of this was already it's already been laid out in the media, so probably you've heard it before. There was a commitment by CSC to in the future, they're working on ways to reach out to the victims so they have a chance to update their victim statements. The unit also had called had 3 witnesses who appeared as individuals, and the Office of the Federal Ombudsman for Victims of Crime, who had some concerns generally about, you know, the information sharing with the victims. There's some concern on his part that there's a lot of onus on victims to take steps to obtain the information, right? Registration. There was some suggestion that maybe the victims could, when they give a statement for the court, they could at that time, or somebody from the court could take their signal that they want to receive information. So earlier, you know, removal of a step later. So some discussion around that. So some discussion about ways things could be better in the future. On December 4th, the lawyer for the victims' families, that's the French and Mahaffey's families, Tim Danson appeared, but there was no evidence available for that. And then December 6th, drafting instructions for a report there, but no evidence or minutes, so I couldn't tell exactly what that was about. It was just a odd reference there, which I hadn't really seen before, so I wasn't sure what to make of that. And then on December 11th, there's a private member's bill that they're looking at, or began discussing Bill C 320, which is an act to amend the CCRA regarding the disclosure of information to victims. However, when I read what that bill is actually about, it's about the description indicates it's about sharing an explanation on the calculation of dates for releases, ETAs, so an explanation on about those dates, how they arrive at those dates. So it's doesn't appear to be anything to do with some of the stuff I just referred to, like providing more information to victims. At least that's what I judge from the description of the bill itself. If anybody knows more about 320, please feel free to chime in here. Because I couldn't extract with the name of it and the topics discussed recently, you'd think maybe there might be something in the works there to help with the sharing of information regarding, you know, with victims, regarding transfers, et cetera, given the concerns around that. and issues, but I'm not seeing that in the description of the bill. And that is all. So if there's any questions, or if anybody has anything to that they know more than what I've said about either 320 or what was the other thing there? There was something else. Okay, I'll just stop there. So any questions?
Thanks, Rob. Much appreciated. Matthew has his hand up.
Rob, this particular report that apparently is going to be written by the standing committee, I'm a little worried about it. And I'm hoping that you will be able to monitor it and share it with us. We now have a situation where victims are demanding input on transfers. They already have input on parole hearings. A legitimate victim can make an appearance at a parole hearing, but I'm just kind of wondering, to the extent to which a victim input on transfers is going to mean less cascading down, which is in direct contradiction to the CCRA, to BSNet and other policies. So, Mr. Chairman, is it appropriate for me to request further monitoring of this report? We may need to do some testimony, because I suspect there's going to be more bills tossed at this.
Oh, sure, Matthew. That's a legitimate request.
Can I jump in just for 1
Yeah,
second?
yeah.
Maybe I didn't make myself clear earlier. I'm sorry if I didn't. I'm not sure what that report, there was a reference to drafting a report right after the Bernardo transfer victim sharing information meetings. I'm not sure what that report is going to be about. It didn't say, there were no minutes. It was just on the website, it shows a reference to or drafting instructions for report with nothing else. So I just don't want to the committee to take from me anyway that there's a report going to be written. I'm not sure about that. I'm not sure what that report is. So if someone here knows more than that, about that there will be a report for sure, I have no problem doing whatever you want me to do, keep an eye out for it or whatever. Just don't take from my comments here, because I'm not sure what that report is at this moment.
Yeah, thanks, Rob. I mean, for sure. I mean, the committee is going to generate a report. It's what it does after its hearing. So, and for your sake, Matthew, Rob will keep us informed as to what happens with the committee and when the form is generated, and we'll look forward to that and follow it, as closely as Rob can do. Is there something else above that, Matthew, you wanted?
Just a little bit of information. There is research indicating at parole hearings that when victims show up at a parole hearing to oppose parole, the convict is less likely to get any form of conditional release.
Okay. Well, again, I'm not so sure that'd be reflected in a report, but is that anecdotal, or do you have published material on that?
I'd have to find it.
Okay. Anyway, as I said earlier, Rob will keep track of this for us as it goes through its committee process, and when the report's generated, we'll take it up at whatever meeting that happens to be. So thanks, Matthew, and thanks, Rob. Any other questions for Rob on his report? Okay, thank you. All right, the next report is Brendan's report on the Senate Legal and Constitutional Affairs, and he's provided me with his report, so I'll read it into the record. So basically, the committee has met 14 times since the last PRC meeting in October. They've discussed a variety of bills. The majority of these meetings was dedicated to discussing miscellaneous business, including reviewing the Interpretation Act Bill S13. There was also a review of a report on the Statutes Repeal Act for 2023. He has some notes on 3 bills. The first one is C-48, which is the bill to reform the bail reform process. That's no longer a bill. It's now enacted. It has royal assent, which was, let me just see here now. It's in our notes. Royal assent was granted on December the 5th, so I'm not going to read into the record the committee's report or the committee's proceedings on that bill, because again, it's now a statute. Bill S-231, an act to amend the Criminal Code and the Criminal Records Act, the National Defense Act, and the DNA Identification Act. The committee met 4 times on this matter and proceeded to a clause by clause on December the 7th. This was a private member's bill tabled by Senator Claude Kerrigan. It is designed to increase the use of DNA collection by various means. This would include young offenders. It would include any offense where the maximum penalty is at least 5 years in prison. An apparently controversial piece of this legislation is opening up DNA searches to familial searches, that is, looking for close matches and exposing innocent family members to interactions with the justice system. A number of witnesses were heard from, including the Canadian Association of Chiefs of Police, various representatives from the Office of the Privacy Commissioner, DNA Databank Advisory Committee members, forensic scientists, Crown attorneys, and several witnesses from the Native Women's Association of Canada. Witnesses were split on the bill. Some felt it was a minor infringement upon the privacy of individuals, but would greatly increase the ability of police to identify criminals, which is a position supported by the chiefs of police. Others felt that it is a serious privacy risk to a significant amount of people, even in situations where DNA might not be helpful, i.e. fraud cases where DNA is unlikely to be a factor. They caution against potential misuse of this data in the future and how it may lead to genetic discrimination. Notably, there was a significant hope from the NWAC that this act could help the missing murders of Indigenous women's cause and identify remains more easily. They offered the caveat that should more extensive searching and familial searching be used to target Indigenous peoples, they would reevaluate their support. And clause by clause review, some discussions on the clauses were a bit technical and hard to follow, but several core clauses in the bill, such as not allowing for family searches, for not applying DNA requests to those found not criminally responsible, etc. This led Senator Carnegie to feel that this bill no longer reflected his original intentions. This bill has not yet returned to the Senate. Any comments on that? Again, of course, it's a private bill. Yes, Irving.
No, I don't have anything.
Oh, I just say, okay. Yeah, this is interesting. And most of you probably already know. I mean, the provisions for the extraction of DNA from those who come into contact with the criminal justice system in Canada is very, very limited. It doesn't occur at arrest. It occurs after sentencing, and it totally depends upon the severity of and the nature of the crime for which the sentence is imposed as to whether DNA will be collected. And there are 4 levels of indicia that lead to collection, from automatic to almost never. Much different than most states in the United States, and very different from the UK. The UK, allows for DNA collection on someone being picked up and not even charged. It's an automatic process, virtually, which obviously leads to an extensive DNA database in the UK, which is used for all kinds of purposes. And for this, and then it's for that reason, of course, that the Canadian Association of Chiefs of Police want the same kind of thing, to create a national data bank that has some depth to it. Ours doesn't. So it's interesting. This bill is interesting, but where it heads, we don't know. But if it did have traction, and I don't know if it does, it would change the way that DNA is collected in Canada, which is a big deal. With respect to privacy issues and again the breadth and the depth of the data bank itself, which is quite interesting. Anyway, we'll keep an eye on that. It's Brendan will report to us. He's going to be here next month, so we'll see what happens with that particular committee. The next bill that he studied was S-230, an act to amend the Corrections and Conditional Release Act. The committee met twice on this issue. This is a bill presented by Senator Kim Pate. It has several aims, notably ensuring that any detainee with mental health issues be transferred to a hospital, ensuring confinement to an SIU longer than 48 hours requires an order of a superior court, allows for the provision of correctional services and plans for release and reintegration into the community to persons from disadvantaged or minority populations by community groups and other similar support services, and allows for those sentenced to a period of parole ineligibility to apply to the court for reduction if there has been unfairness in the administration of their sentence. Several witnesses appeared, including various criminal defense lawyers, John Howard, Elizabeth Fry, and law professors. Concerns were raised from senators about the practicality of transferring what they believe will be a large amount of mentally ill offenders to provincial hospitals when psychiatry wards are already overburdened. There's general support for the idea of dealing with mental health issues in prison. There's support of the bill from all witnesses so far, notably Correctional Services Canada declined an invitation to testify, and the meetings are ongoing. Okay, that is Brendan's report, and again, we'll return to it and what else he has to add. There very likely will be very little more committee work between now and our next meeting due to the holidays, but we'll see what happens. Any questions or concerns for Brendan's report as presented? All right, thank you. And lastly, parliamentary wise, we have a report from Dick with respect to the human rights in the Senate.
Well, there are four topics I'll be touching on briefly in this update. First of all, Islamophobia. On November 3rd, the committee released its report on Islamophobia entitled Combating Hate, Islamophobia, and its Impact on Muslims in Canada. The report outlines the committee's findings from its year-long study into the sources of Islamophobia in Canada, incidents of discrimination, physical violence, and online hate against Muslims, and the effects of these events on individuals and communities. The committee made 13 recommendations, including calls for new educational campaigns and resources, new criminal code offenses for hate-motivated crimes, and enhanced data collection by CRA's Charities Directorate, which disproportionately scrutinizes Muslim charities. And of course, that report's available online. The second topic that the committee has been dealing with is anti-Black racism, sexism, and systemic discrimination in the Canadian Human Rights Commission. Yesterday, December 11th, the committee released its report, which makes 11 recommendations, including the federal government should appoint a Black Equity Commissioner, modernize human rights and employment equity laws, and hire an independent expert to review workplace conditions of Black, Indigenous, and racialized employees of the Canadian Human Rights Commission. The report, or the committee noted that witnesses described a toxic culture at the commission and provided specific evidence of systemic discrimination. The testimony and written submissions demonstrated a crisis of confidence in the federal human rights system and underscored that no institution is immune from systemic racism. Third topic, human rights of federally sentenced prisoners. The committee's report on this topic was tabled in the Senate over 2 years ago, June of 2021, and on October 23rd of this year, the committee began its consideration of the government's response to the report. And that's all I've got on that. And the last topic, which is their current focus, is forced global displacement, or refugees. On October 30th, the committee began its consideration of this topic and heard from several witnesses. And since then, there have been 3 further meetings hearing from more witnesses. And that's it.
Yeah, thanks, Dick. Matthew has his hand up.
Dick, thanks for this. Really quite interesting. I don't know what to say about the Canadian Human Rights Commission and this recent brouhaha. I happen to have a close friend and colleague within the commission, and he has been witness to the toxic culture and a recipient of it. And so I just shake my head. I mean, these folks are supposed to be handling human rights complaints. But man, the second question I have for you is the question of human rights in federally sentenced prisoners. Did the report make any comments about racism or structural racism experienced by inmates?
You know, Matthew, I just don't know because I haven't gone back to the report to read it. I was just this was released 2 years ago, so it'd be easy to find, but I can get back to you on that.
You know, if you would be, Dick, so kind to send me the URL link. I have a client right now in the federal system, Black, who's complaining about racism and tells all the staff about his concerns, and they tell him to stop complaining about racism. What am I supposed to do?
Right.
Yeah, thanks, Matthew. Thank you, Dick. Anything else regarding this report? Okay, that closes the parliamentary reports. Thank you very much, everybody. Next, with respect to other issues on business arising, I'll just refer to those that are live issues. So item D, this is the proposal to put forward to seek provincial, territorial, and federal support for including criminal records as grounds for discrimination in human rights codes. We talked about this before. It's going forward. Right now, it's in the hands of the Uniform Law Conference of Canada. And I received correspondence on the 22nd of November of this year from Matthew Taylor, who's counsel for the ULCC. And here's what he had to say. He said, so it seems that the consensus that is emerging is that consideration of the issue, that's this issue obviously we brought to their attention, and taking it on as a study item would need to be done at next year's meeting. In the meantime, the executive of the ULCC are going to discuss further with one of the committees, the Advisory Committee on Program Development and Management, whose responsibility includes identifying projects or topics that can be recommended to the conference for study. We have shared your paper with them to facilitate the review of the issue. We will keep in touch as things develop further on all of this. And that's pretty much in line with what Howard expected. He has experience with this committee. It will be reviewed in the summer. That's the next time the board meets, July or August, to review the projects they're going to take on. And Matthew indicated to me in my first Zoom call with him that they'd invite us or myself, whatever, to appear before the committee as they review the issue of whether they're going to endorse, and I think they likely will, the issue of creating a ground of discrimination being a conviction across the country. So for both employment purposes and housing purposes. All right, so that's where it stands. So it's positive at this stage of the game. It's going through their process. We can't do much about that. They have to do what they have to do. And we'll return to it when we have a further update. Any questions about that particular issue? All right, so again, it's moving forward. All right, so bills under consideration. Trying to keep the meeting within our time frame. So all I'll really do for the bills is basically refer to those that have either moved to royal assent and or those that have been introduced since our last meeting. So let's just see now. So firstly, we're dealing with public bills for the Commons. And as we mentioned earlier, Bill C-48 to amend the criminal code regarding bail reform received royal assent on December the 5th. So that's that's done. Private member bills in the Commons, there aren't any changes to any of those in real terms, unless we have some that have first readings. So Bill C-364, an act to amend the criminal code regarding sentencing, had first reading on November the 9th. So this enactment amends the criminal code to add as an aggravating circumstance for sentencing purposes evidence that an offense was directed at persons or property that were vulnerable due to long response times by emergency services or due to the remoteness from such services or from an established community, and for the purposes of some offenses, the fact that a person carried used or threatened to use a weapon or an imitation of a weapon. It also requires that a court, when exercising its discretion to grant credit for time spent in custody in determining the sentence to be imposed on a person convicted of an offense, consider their reasons for detaining the person in pre-sentence custody. That's a pretty broad bill. Any comments for discussion?
I hope we will oppose it.
All right. Well, I mean, I have no problem doing that. So keep it in mind. We'll see how it progresses. When it gets to committee, we'll consider a brief. Okay. Anything else? All right. Bill C-367, an act to amend the criminal code regarding the promotion of hatred or anti-Semitism. This enactment amends the criminal code to eliminate as a defense against willful promotion of hatred or anti-Semitism the fact that a person in good faith expressed or attempted to establish by an argument an opinion on a religious subject or an opinion based on a belief in a religious text. That had first reading on November 28th. Any comments? Okay. And lastly, in the Commons, Bill C-370, an act to amend the criminal code regarding the unlocking of electronic devices. So this enactment amends the criminal code to provide that a judge may make an order compelling a person to unlock an electronic device. So there we go. Any comments? All right, that's it for the Commons. In the Senate, we have royal assent to Bill S-12, an act to amend the criminal code, the Sex Offender Information Registration, and the International Transfer of Offenders Act. So I'm not going to go through the text of it. It's in your agenda. And it received royal assent on October 26th. And private members' bills, we have Bill S-281, which should have been included in the last agenda. This is the one that Peter has brought to our attention. This is a bill to amend the Corrections and Conditional Release Act regarding parole review. So this enactment amends those acts to provide that in the case of an offender who is serving a sentence for first-degree murder or second-degree murder, parole is reviewed in accordance with the statutory timeframes, not on application by the offender. Once the board has decided, that's the parole board obviously, has decided not to grant day or full parole to the offender or to cancel or terminate the offender's parole. So Peter had given us, and I included in the agenda, a link to a news article regarding this issue. So we'll leave it to Peter on his return next meeting to go into this further. Any questions or comments?
I'm unclear what the drafter of that legislation is trying to do.
My
I mean,
understanding.
the statutory requirements for parole review are in the act.
Yes.
Are they saying that they do not want the board to exercise any discretion to advance those dates or consider paper decisions? I'm unclear what is trying to be accomplished here, except to delay parole.
Well, I think you're correct, Matthew. I think that's the end game, is to delay parole decisions, make them as difficult as possible, and certainly affect the timing to some degree. I haven't read the bill in its entirety, and that's perhaps why Peter has sent us his news clip regarding the bill, and I presume Peter can enlighten us when we return at our next meeting to discuss this, because it's certainly something that Peter has brought to our attention.
Is this not about reducing potential harassment of victims? By, the guys like Bernardo asking to, well, yes, if he can ask every year, now that he's beyond 25 years, to go in front of the parole board. And then I'm not certain this is exactly the case, but it's happened in other cases where the individual can get a parole hearing every year, even though there's no chance that the individual will actually get parole. And sometimes they'll fool around and the victims show up and they said, well, you know what, forget about my application for parole. I'll just let it ride. And they'll do every year. They'll basically harass the victims. I'm wondering if that's not the nub of the bill.
I think you're right, Irving. I think it is, and I think it actually goes back to Bernardo and the Mahaffey, families, that they have to endure, the indignity,
trauma.
The trauma and indignity of appearing at a parole hearing and face Bernardo, and I'm pretty sure that's the nexus of what the bill relates to, and obviously other points as well. So again, we'll revisit this in more detail and see what Peter has to say at the next meeting. Yes, Matthew.
This is another example of legislation by
Exception.
atypical case. One of the problems from a non-victim point of view is that Bernardo's incarceration of 30 years of maximum security was likely a civil rights and a charter violation. And in my humble view, and I know there'll be disagreement on this, the CSC was aware that they were exposed to a judicial review on this. And if you're going to allow inmates to try to get conditional release, the set off on day parole denial is 1 year. The set off on regular full parole is a 2-year set. If you are convicted, however, as a dangerous offender or murder, the set off can be 5 years under Harper legislation. So, as an association with expertise in this area, and a lot of us haven't, they've worked in agencies or what have you, we're going to have to take some positions on this stuff because we're going in a crazy direction.
Well, and absolutely right. I mean, we know that. I mean, there's a vast majority of legislation that's introduced is a knee-jerk reaction to the issue of the day. We get that. In this particular case, it's a private member's bill in the Senate. Whether it moves past first reading, we'll pay attention to it. I mean, each month I bring in these up to date. So if it does move to a second reading and what have you, then we'll see whether a report at committee is what we're looking for. Good point, though, Matthew. Thank you.
Yeah.
All right, everybody. That is the content of today's agenda. Does anybody have anything to add for the benefit of the group?
Are we meeting in January?
Yes, our next meeting will be January the 9th, I believe.
Great.
Absolutely. Look forward to it. All right, everybody, all the very best of the holiday season to each and every one of you. It's been a delight to work with you over the course of the last year, and I hope you have a great holiday.
Happy holidays, everybody.
Right, take care, everybody.
All the best, guys. Bye-bye.
All the best.
All the best. Take care.
Bye-bye. Thank
Enjoy.
you.
Stay healthy.
Yes, sir.